scheduled meeting of the Franklin Ethics Commission. Mr. Jerry Sharber to my left is present. Ms. Vonna Wilson to my right is present. I'm Jim Martin. I'm the chairperson. Our fourth person, Juanita Patton, has recused herself, so she will not be present here today. You're having trouble hearing us. Is that better? Can you turn this mic up some? All right. Thank you. First item of business is the minutes from the meeting of June the 15th. Have each of you received these minutes?
I have.
Do we have any changes, corrections, additions, or deletions to the minutes?
Mr. Chairman, I don't have any changes or corrections. I'll even make a motion to be approved. But in other business where Commissioner Patton excused herself, I would like to bring up a subject in old business of our meeting today that's connected to that.
Go ahead.
You want me to wait and do it?
Do it now.
Do it now? Okay.
Well, first we've got a motion on the table, and is there a second? Because we need to just go ahead and get that cleared up before we talk about your
I'll
thing.
second the motion.
Okay.
Then we have a motion and a second. Now discussion. Go ahead, Mr. Sharp.
In section 306 of the Ethics Code, it says, if you don't mind me just reading, the Ethics Commission and its attorney shall be governed by and subject to this chapter. If members of the Ethics Commission have a conflict of interest or must disqualify themselves under this ethics code or by the law, the remaining members shall at that time choose an alternate person mutually agreed upon to hear that matter. That's what it says in 306. What that says to me is that the three of us are going to select a fourth person to replace Juanita for that one meeting that she has a conflict with. So, how do we proceed?
Let me take a look at your section.
There it is.
I got it.
Okay.
It does say shall.
I stumbled across this while looking for something else.
Well, one, I appreciate you bringing this to our attention. Number two, when Ms. Patton recused herself at the last meeting, she did so because it was evident that an issue that was going to come before us involved an organization in which she is a member. That's the African American Heritage Association. But we didn't act on it. So I don't think there was anything that we had to have a member for present at that time. In other words, she recused herself from consideration. The only thing we did was to set it for a hearing today to determine probable cause. Now the question becomes, should we have another member today? I think, isn't that where we are under this section? Ms. Billingsley, how do you read this?
Well, because the initial determination hearing is a creation of your own bylaws, I think you can have this hearing today and decide whether or not it's really just a discussion whether or not it's a colorable claim. If you decide to move this forward and set it for hearing, you will need that fourth person at that point. So my suggestion would be have this hearing today, decide whether or not it is a colorable claim. If it is, then during other business, we would set a hearing or another meeting to nominate and appoint this fourth member before we have the actual hearing on the merits. I do not think you have to have one today.
So what do you do if you have the meeting and decide that there is a colorable claim? You select a fourth member and that person says, but if I had been present, I would not have agreed with you.
That still would have been just one vote.
I'm sorry?
It still would have just been one vote, and you
Well,
would have moved
yeah,
forward.
right, and suppose we've got a split today where we've got 2 for, 1 against, and that fourth would have given us a stalemate. Do you understand what I'm saying?
I do.
So it seems to me that if we're going to have a fourth person that participate in this, they need to be involved in the initial determination.
I mean, that's really your call. I don't think that they're needed until you have, the only thing that's contemplated in the code is a public hearing on the merits, not the initial determination hearing, which was created as part of your bylaws. And that is where you need to have all members present, even your substitute members.
So your distinction is between the provisions of the Franklin Municipal Code and what's required and what our bylaws have provided
That's right.
in terms of our initial determination.
Because you don't need a substitute member if you don't go to public hearing.
Okay, I understand. So, Mr. Sharber, what are your thoughts?
I agree with Shauna in that the notification was provided by a member that they're going to have a conflict. And the notification is that they would not be here today because of, this is just an initial determination meeting to determine whether the complaints are callable or not. So it seems to be that if you go to I'll just call it the next step, that you're going to need I'm going to say a replacement for the one member that has a conflict. And that replacement, ironically, is determined by us, not the Board of Mayor and Aldermen. Now, we also have a vacancy, as you know, and the Board of Mayor and Aldermen will determine that. But this is like, and it says shall, the remaining members shall, at that time, choose an alternate person. I mean, it doesn't even give us the latitude of proceeding on with 3 members, which is a majority. So I do think we're going to have a fourth member. It's a matter of when, and I agree with what Shauna told us. I think we could probably have, unfortunately, another meeting just to determine who the fourth person is, and then proceed on if that's what we decide today. If we decide these are not callable claims today, all of this is mute. It doesn't mean anything.
Ms. Wilson, what's your thought?
I think we have our meeting today and decide if we need a hearing, and if we need a hearing, then we have to schedule an extra meeting to find our fourth person.
And Ms. Billingsley, is there any procedure for making suggestions to the commission of who might be willing to serve, that kind of thing?
Yes, in the bylaws, we have adopted Robert's rules, and the way Robert's rules work in situations like this, you would need to do your own sort of homework. So hopefully, by the end of the day, during other business, if you decide to move forward, we will set the public hearing today as well. So we'll have 2 dates we'd have to set. You would need to talk with the people you would like to nominate and let them know that this is the hearing date, so they have to be available on that date. We have to work within those 60 days. At that point, when we come to the meeting to nominate the fourth person, each of you have the right to nominate, and we open the floor. So you would say, I'm opening the floor for nominations. Everybody throws names in, and then you will take them one at a time. And the person that has the most votes is your fourth member. That's how Robert's Rules contemplates nominations.
But we need to know from persons that we nominate their willingness to serve.
You would
before
have to have that conversation with them before you come and nominate them. And they have to live in the city. That's the requirement.
Mr. Chairman, I'll make a point here. In thinking through after I read this, that's the reason I said I moved to approve the meeting minutes, but there's a subject in other business that I want to bring up today in our meeting. And other business. Because if we decide today these claims are not callable claims, then this whole discussion is moot. So I think we should continue this discussion, vote on our meeting minutes, and continue this discussion in other business, if that makes sense.
I think that's fine. Then we'll go ahead and approve the minutes.
Yeah, I made a motion. I
And
don't
it's
know.
been seconded.
Okay.
So all in favor, say aye.
Aye.
So we all approve the minutes. I vote in favor as well. The next order of business then is to consider the complaints that have been filed. Can you all hear me all right? Is it loud enough now? Okay. So the next order of business is to consider the complaints that have been filed. There are 7 complaints. And each of you should have copies of these complaints. Do you, Ms. Wilson? Mr. Sharber?
Yes.
Very good. The first was filed in June the 7th, and the latest was filed June the 14th. They're all timely, based on our provisions. And all of the complaints allege violation of the Franklin Municipal Ethics provisions as found in the code, and they emanate from a letter that was written by Alderman Gabriel Hanson on June the 25th of 2023, if my understanding is correct. Or maybe it was May the 25th.
May 25th.
Is it
May.
May the 25th of 2023? See, I had the date on that letter. The letter is reproduced a couple of times, but the date of it was not. Let's see if I can find it.
It was an email, and I don't find
You
a date
You don't find a date either?
associated with the email. It does reference, the email itself references some things that are related to time, to a timeline. I don't know that we have that. I don't know that we
The date
have
of the letter?
the actual
The date of the
date
email.
of the email. We have the email, but everywhere it's offered to us, it is not
Okay,
offered.
here we go. In Mr. Jensen's complaint, he alleges that it was sent June the 5th of 2023. June the 5th of 2023. Okay. So that's as close as we can come to dating it based on these complaints. And then the first complaint we had was June the 7th, and then the last one was June the 14th. So they're all timely, is what I was trying to get to. The code requires that the complaint be made within 30 days of the alleged conduct that the complainant believes constitutes a violation of the ethics provisions of the code. So then we have complaints from Ms. Jenkins on June the 7th, Ms. Kingsbury on June the 8th, Ms. Rogers on June the 9th, Ms. Schaus on June the 9th, Ms. Osher on June the 9th, Mr. Berger on June the 11th, and Mr. Jensen on June the 14th. The letter in question was a letter to Mr. Kreulen, Kreulen, and the board of BNA Airport. And the sections of the Franklin Municipal Code which are alleged to have been violated are 805, 807, and 808. And as Mr. Sharber mentioned earlier, the purpose of today's proceeding is to make a determination on whether or not the allegations of the complaint are sufficient to constitute an ethical claim if proven. And if not, what are the deficiencies and whether the complaint is incomplete. So if we turn to 805, which is the code, first code section that's alleged to have been violated. That code section essentially says that no official, and I'm redacting as I read here, no official may solicit anything of value for themselves or any other person if it tends to influence the official discharge of their duties or gives a reasonable basis of improper influence over the discharge of official duties, or they have a financial interest which may be substantially and materially affected by the performance of their duties. That's in Section 1. Section 2 talks about gifts and gratuities that are not prohibited because they're listed in the Tennessee Ethics Commission Act. And then Section 3 talks about attendance at events and that kind of thing. So, members of the commission, if you read 805, then the question becomes, was there a solicitation by an official on behalf of another person which, and then that's when the if comes into play, would influence that official in the discharge of their duties or give a reasonable basis for the impression of improper influence over the discharge of official duties, or in which they have a financial interest, or where they would be materially affected. Now, is that a fair reading of the section?
I think so.
You think so?
I think so.
So that's 805 summarized. Then we get to 807, and this is dealing with municipal time, facilities, etc. And Ms. Wilson and Mr. Sharber, I have trouble here. I'm not clear how any of the allegations fit within 807, so you all will have to help me on that. The letter of June the 5th of 2023 doesn't appear to me to have been generated on municipal time, facilities, or equipment or supplies, nor was it done for private gain or advantage to the author.
Mr. Chairman?
Yes.
Ms. Jenkins makes a reference to 807 paren 2.
Okay.
In her complaint. There's actually several parts of her complaint, but she makes a reference to 807-2, determining that the government body has to be in the best interest of the municipality from section 807 paren 2. And the question of whether there's a legitimate contract or lease to do that. She makes that point. We do not see, or I have not seen, a contract or lease the city has in order for Ms. Hanson to represent the governing body. I think that's what Ms. Jenkins is saying, if that makes sense. In other words, Alderman Hanson could have functioned on behalf of the city if there was a lease or contract, but there was not one. Therefore, based on what I understand from Ms. Jenkins, Alderman Hanson was not operating.
Well, the quotation in the complaint filed by Emily Jenkins, that's the one you're referring to?
Yes, that's correct.
And it's on page 2 of her complaint at the top. And it says the ethics policy further states,
Yeah, ethics policy. See, she says, and she quotes 807(2), and she says they may not use the authority unless, or except, as it says, as authorized by a legitimate contract or lease that is determined by the governing body to be in the best interest of the municipality. I understood what Ms. Jenkins was saying, is that she sent the email, the letter, from her city address using her official title in order to wrongfully extort funds for the AAHA, which is a violation of the ethics policies. Now, she didn't say it this way, but it brings up the question of, was Ms. Hanson operating and representing the city because there is a legitimate contract or lease? You follow me?
no, I do hear what you're saying.
Now she being Miss Jenkins did not exactly express it that way, but she did quote the section, which is 807(2).
I don't see where 807 is particularly in this situation. I understand it was listed. But the use of municipal time, facilities, equipment, or supplies.
And it's very possible that's what Miss Jenkins was making reference to. And if that's all she was making reference to, then I think you're totally correct. I think we would have to discard that part.
I think she's quoting from 808, not 807.
Right.
I think she's quoting from 808 too, and not 807.
I'm sorry, maybe I did you, Mr. Chairman, did you say that you thought 807 was not?
Yeah, I don't see 807 as being, I mean, it's referenced by some of the complainants, but I think Ms. Jenkins in her complaint in paragraph 2 is actually, even though she didn't number it this way, is referring to section 1-808 subparagraph 2. And that one redacted says officials may not use or attempt to use their position to secure any privilege or exemption for themselves or others not authorized by charter, general law, ordinance, or policy of the municipality. Now, that's the first sentence of 808 subsection 2.
Well, that could be the issue, could be that the section that she used was really 808.
Yeah, and she just, it wasn't actually numbered,
It
but
wasn't
Right, it
numbered.
was not numbered.
Yeah.
You had to take what she said and try to find that in the charter.
yeah, and I think she's really referring to 808 subsection 2. And essentially what she's complaining is, I'm talking about Ms. Hanson. When you read the email from Ms. Hanson to Mr. Crulin and the board, the complaint is that they have made a pledge to the Franklin Justice and Equity Coalition, and Ms. Hanson wants them to commit to make a pledge of comparable amount to the African American Heritage Association.
And that is in a different section of Ms. Jenkins' complaint. That's her
I think
item 2.
that's item 2
Yeah,
on page 2.
I'm sorry, I thought you were talking about item 3. Yeah, she did make that an item 2.
Yeah,
That's correct.
Yeah, and,
In her item 2,
so if you
she's referencing 808 print 2.
that's right.
Yeah.
She didn't actually
Say that, but that's what she
quotes from
quoted.
that. Right.
Yeah.
And when you read that section redacted, it reads, officials may not use their position to secure any privilege or exemption for themselves or others not authorized by the charter, general law, ordinance, or policy of the municipality, or attempt to do so.
Correct.
They can't use it
Yeah.
or attempt to do it. So the issue then is, does the communication of June the 5th, 2023 rather, constitute a violation of that prohibition, at least in terms of a colorable claim? Now, we'd have to hear from the complainant, we'd have to hear from Ms. Hanson, and
Exactly.
but it may be that after hearing all of it, we would conclude that there's no colorable claim or there's no violation.
Yeah, we would just have to make that determination at that point in time.
That's right.
After having heard from Ms. Jenkins and Ms. Hanson, Alderman Hanson.
So let's see if we can summarize where we are. If you go back to 805, which is one of the sections that's quoted, and I read that in a redacted format a minute ago.
And that's fine.
Yeah. So reading it again in a redacted format, it says, no official may solicit anything of value for themselves or any other person and then it starts with a new sentence. In addition, it's a violation of the code if any gift is to be received under these circumstances here. So if you look at the first, I mean, there seem to be two prohibitions in 8051, okay? One is the first sentence, which is a standalone sentence. Except as provided in this section, no official may knowingly solicit anything of value for themselves or any other person or any member of their family. Then the question is there an exception? that would authorize the solicitation. And the exceptions are gifts, gratuities, and honoraria authorized by the Ethics Commission Act, and then things when the official attends an event and the official electronically reports the information in subsection 3. None of those sections apply. None of those exceptions apply.
Right.
So
Right.
we have an allegation under 805. Then you have 807. And this is where I was. When I read the communication of June the 5th, 2023, I can't fit it within any of the allegations, any of the provisions of 807, but you all take a look at it independently. 'Cause there's no claim here that there was a use of municipal time, facilities, equipment, or supplies for private gain or advantage. Either to Ms. Hanson or to a private person or entity, unless I'm overlooking something.
You're in 807.
I'm in 807, yeah. I could be overlooking something, and you bring it to my attention if you see it, but I didn't see in any of the complaints an allegation that there was a use of municipal time, facilities, equipment, or supplies for private gain or advantage to Ms. Hanson, or the use of municipal time, facilities, equipment, or private gain or advantage to a private person or entity other than her.
I do not see it. Do you, Mr. Sharber?
Well, is your thinking is associated with the may not use the municipal facilities, equipment, supplies, or private gain or advantage? Is that what you're saying?
Well-
Is that does not meet what Ms. Jenkins was saying?
I just don't find any evidence, any colorable claim that there was a use of municipal time, facilities, equipment, or supplies. In other words, we don't have any evidence that
I agree with that, but it goes on to say that except as authorized by legitimate contract or lease, that is,
well, that's in subsection 2.
that's correct.
So I was looking at subsection 1, then you go to subsection 2, and this
Oh,
is the
you're
use-
breaking it up into two. Okay,
Then
okay.
then you go to subsection 2, and that's the use of municipal time, facilities, equipment, or supplies for private gain or advantage to someone else, except as authorized by contract or lease.
Correct.
Well, I don't see where we've got the allegation of that either.
Well, we don't know if there's a contract or a lease.
Well, you don't, yes, but the predicate to that is the use of municipal time, facilities, equipment, or supplies. So, in other words,
Commission
unless I'm
members?
overlooking it, we don't have an allegation, for example, that Ms. Hanson was using a city computer to compose her email. Or that she was using a city facility, or that she was using city time, or city supplies. You see what I'm saying? So the whole predicate to subsection 2 dealing with an advantage to someone else is that you still got to have the use of municipal time, facilities, equipment, or supplies. If you do, then you get to the question of contracts and leases. So
Well, see, it says or. And it says except as authorized. See,
Right.
the way I'm saying that is, to me, it don't make any difference what Alderman Hanson was using. The question becomes, was she acting under a contract or a lease that the city had?
Commission members, my name's Caitlin Parham, and I'm outside counsel for the City of Franklin. And I just wanted to point out that in Ms. Jenkins' complaint, Section 3, it appears she's alleging that the use of Ms. Hanson's provided city email address violates 807 subsection 2 and her title. So I just wanted to clarify that.
Okay. So it's your opinion, that's what she was complaining about?
From the complaint, it looks like she was quoting 8072 and then adding that she believes Ms. Hanson's use of her provided city email address with her official title does violate 8072.
Yeah, that's exactly what it says in her complaint.
But let me back up. But when you read the June 5th, 2023 communication, it's signed, "Sincerely, Gabriel Hanson, City of Franklin, Alderman at Large," with a telephone number. Where is the allegation that she's using a City of Franklin email address? Where is that?
She would have to prove it in her hearing.
Do what?
She would have to prove it.
No, well, where is it alleged? I mean, it says it's an email from Alderman Hanson, then the email is quoted.
The email is actually copied in her complaint.
You're
But-
talking about Ms. Jenkins.
Correct.
Yeah, well, it's copied several times.
Yeah.
I mean, Mr. Jensen's got it in his complaint as well. But,
Mr. Chairman, one of the things that I think of is that since 808 specifically addresses position,
well, we'll get to 808 in a second.
Yeah.
Okay.
Let's kill 807 first.
okay.
Let me go back. Is there any allegation in any of these complaints that Alderman Hanson used her city email address in the communication? Because I may have overlooked it. If I did, then I need to be corrected.
Give me 1 second and I'll double check.
It does
We're
say
gonna pull it up.
Ms. Hanson sent the letter from her city-provided email address
And whose-
using her
whose-
official
whose-
title.
whose
Miss
complaint?
Miss Jenkins. That is what Miss Jenkins says.
Okay.
We don't see it.
Then I stand corrected. You can't tell it from the face of the email itself.
Right.
No,
You
you
can't.
But
cannot.
the allegation is there.
Yes.
Right.
All right, fair enough. Then let's go to 808. Um, 808, see again, if we redact it, says officials may not use their position to secure any privilege for themselves or others not authorized by charter, general law, or ordinance of the municipality, or attempt to do so. And that's the first sentence of 8082.
And that's the reference Ms. Jenkins you said 8082, correct?
Right.
That's the reference Ms. Jenkins is making in her item 2.
Right. But when you read Alderman Hanson's communication, a fair reading of it is the communication to Mr. Crulin and the members of the board of B&A, complaining that they've made this pledge to the Franklin Justice and Equity Coalition, and that they need to make a similar contribution to the African American Heritage Association.
That's correct.
She represents herself as an elected official, and she signs it as an alderman at large for the city of Franklin.
Right.
Correct.
So the question is whether that presents then a colorable claim of violation of any of the provisions of the Franklin Municipal Code on ethics.
Correct.
And that thread runs throughout all of the complaints,
It does.
okay? So do we have a motion?
On all of them or just that one?
I mean, we've talked about 805. We've talked about 807, and that's the use of municipal time. And now we've talked about 808.
I make a motion.
Okay, go ahead.
I make a motion that we move forward with a hearing to understand, based on these specific areas of the ethical code that are in question, and that we would like to understand more.
So the motion is that the commission finds that there is a colorable claim that
Yes.
the communication has in fact violated sections 805, 807, and 808 of the Franklin Municipal Code.
Yes.
Mr. Chairman, I have a question about Ms. Wilson's motion.
All right.
Does that encompass all 7 complaints or just a specific complaint? I understand we're going about this from a perspective of looking at the sections of the charter. But we just said most all these complaints have reference to this. The reason I think this is important is that all 7 would have an opportunity to present their complaint by our procedures.
I think it's Ms. Wilson's intent, and she'll have to speak for herself, that the finding by the commission at this stage is that all 7 complainants have stated a claim, a colorable claim.
Yes.
That answers my question.
Yes.
If that's a yes, then I'll second your
We got
motion.
a motion and a second.
And I have a comment. I came at this from a little different direction. In a previous meeting, I brought up the fact of what the First Amendment of the United States Constitution grants you, and freedom of speech. However, the United States Supreme Court has made many rulings on free speech, one of which is called the Brandenburg Principle. And the Brandenburg Principle, which is codified in the United States Constitution in Section 395, U.S. 444, says, if you don't mind me just reading this,
Go ahead.
a state may not forbid speech advocating the use of force or unlawful conduct unless this advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. That's the Brandenburg Principle. So after reading that and reading through all these, the way I came about this is basically the freedom of speech is sort of negated if there's a imminent lawless action, which ethical violations and breaking the municipal code is a imminent lawless action. So I read through all the complaints thinking, okay, looking at this against this section of a charter, is there a potential imminent lawless action here? If there is, then you cannot hide behind the freedom of speech. You see how I went about this? I don't know if that's rational or not, but
Well, no, it's not irrational. And I think that ultimately the court might get into the question of the First Amendment is what you're talking about.
Sure.
But here, what we're charged with is to determine whether the allegations in the 7 complaints that we've got regarding the communication of June the 5th, 2023, present a colorable claim that there's been a violation of these code sections. And
And I think all 7 reference what is a callable claim.
they do. They do.
And that's the reason I'm more than happy to second Vonda's motion.
And-
I just want to let y'all know how I went about it, which was a little.
And I understand how you did, and I went about it by parsing the sections,
Yeah.
as I did during the course of this meeting. And I agree with both of you that there has been a colorable claim stated with respect to the violation of all 3 sections, 805, 807, and 808. But I do need some help in the meantime, I think, before we have a full-blown public hearing on this question. And that is this. And let me share this with you all, because you may disagree on it. But when you read 805, it talks about soliciting gifts and things of value for any other person. And the question in my mind is a not-for-profit organization a quote person within the meaning of the code? Okay? And then we had the same issue in 808. And this is, I've been looking at subsection 2, and that's the prohibition against using your position to secure an exemption for yourself or others. And the question is, does the word other under section 808.1, excuse me, 808.2 rather, include a not-for-profit organization, okay? We just have to get our legal counsel to give us an answer on that.
Yes, and that is something myself and Ms. Ashworth, outside counsel, can brief for the formal hearing.
Okay. Have you come to a conclusion?
We will brief it.
All right, you haven't done it yet.
Not yet. No,
I'm
sir.
hard of hearing, and I apologize. So I think those questions will have to be addressed, but they don't have to be addressed until we have our public hearing. But Mr. Sharber and Ms. Wilson, do you see what I'm saying?
I do, and I had several questions about several items, and I'll tell you, I fell down on this. I went to our own bylaws and procedures, thinking that if we have a hearing, how is that going to work? And so it's going to be an opportunity for not only the complainant, but the official to present their case or their position before us.
That's right.
And so, and it also says, and I think this is really important, cross-examination of any party by another party shall generally not be permitted. All such comments shall be addressed to the commission. The next section says, any member of the commission may directly question the staff, the complainant, the official, public members who spoke during the public hearing, or witnesses appearing before the commission at any time during the testimony. I say that to say this, that we're going to have questions during the process, and we're open to ask those questions at that point in time. And I think your question about, is that a person? I think that's a very good question.
Well, that's really a question of law as opposed to a question of fact that we'll need help on.
Mr. Chairman, I also, and you all may know this, I just don't, under Section 805, Item 2, the gifts, gratuities, honoraria, and other things listed in the Tennessee Ethics Commission Act specifically but not exclusively, and it names a code, shall not be prohibited. I have no idea what that list is.
Yes.
I feel like I want to know what that list is.
And we will bring that to the hearing as
Thank
well.
you.
Yes, I'll make a note of that.
Very well. Then I concur with both of you that a colorable claim has been stated by all 7 complainants. We'll have a hearing. We'll be able to hear from each of the complainant. Ms. Hanson will be entitled to respond to each of the complaints. With that being said, then we need another meeting to pick a fourth.
Well, you got to vote first.
Do what?
You got to vote first. You got a motion and a second.
Yeah, we got to vote.
All in favor, say aye. Aye. Oh, so all of it, it's unanimous. I thought I made that clear. So we need a meeting then to pick a fourth person to serve. The problem, of course, is that we've gone through this analysis, made a determination that there's a colorable claim, and now we're bringing a fourth person on board that hadn't had the benefit of this analysis. But that's the way we elected to proceed. So
Yeah, we're limited to that process at
that's
this time.
fine.
I will also say this is being videotaped and on live channels now. They can watch it. So
Yeah.
anybody that,
That's an
or
excellent
if you
point.
want, they can come back and watch it. Anybody that you are thinking about nominating.
We can get, the city will get them the information and they can watch it and get caught up pretty rapidly.
And then may I ask, when we schedule the hearing, it will be public knowledge, so anyone that wants to be a part of that will be here. And do we have responsibility for contacting any specific persons that we want to hear from?
So we will reach out to the 7 complainants. You will today set 2 meetings, one for the 4th member and the final public hearing today. I would like for you to schedule that today so we know what we're working with. We will reach out to the 7 complainants and let them know the day and time. If there's anyone that you're interested in hearing from, you let us know and we will reach out to them as well. But just because someone did not file an actual complaint doesn't mean they're not allowed to speak. It's a public hearing. So once the complainants speak, the public will get an opportunity to also address the commission.
Thank you.
And I envision it, Mr. Sharber and Ms. Wilson, that we're going to have a sign-up sheet. And we're going to have.
We know how to, we are pros at public
Right.
comment.
They are. They're very good at that.
Right, and we're going to have to, we got 7 complainants. They obviously will be allowed to present. Ms. Hanson is going to be able to respond to each of them. She may want to respond to all of them in mass or one at a time, and that'll be up to her. And then we also, as according to our provisions, are allow members of the public to speak. Well, we also have the right to put time limits on it, and we're going to have to. So we need a sign-up sheet, figure out how many people want to address the commission, and then decide how much time to give each one. And that's the way I envision this going.
Excellent.
Otherwise, it could stretch into the early morning hours.
That's right. And normally we have a sign-up sheet, well, it's really a sign-up paper that you would sign. You would say you want to speak and some information about you, and we can number them so we can find out before your meeting starts how many people have signed up to speak. And at that point, you can decide how you want to proceed. And that's generally how we do it when we know we have hundreds of people that want to speak.
And that works well.
We're comfortable with this. We know
That
how
works
to.
well.
Thank you.
All right, so let's set a date
Calendar.
for,
I have one question, Mr. Chairman,
yes.
and I apologize. I don't know exactly where I read this. I meant to make a note and I did not. Alderman Hanson has 30 days to respond.
Right, that's in our bylaws.
It's in our bylaws.
Yeah, so let me give you that.
That period has not passed, has it? Or
No,
has
it hasn't. It's 30 days from June 7th.
Okay.
And that's if she wants to. She's not required.
She may not want to,
Right.
but we'll know, let me just say, July the 7th, as to whether she has submitted in writing or not. Correct? Okay.
Set a date.
So it becomes how quick do we?
All right, now let me back up. So Ms. Billingsley, if I look at, in our bylaws, page 4 of 7, Roman numeral 6, paragraph 4, it says, if the commission holds that the complaint states facts sufficient to move forward, the official against whom the complaint was filed shall reply in writing. So it's not it's not elective. There must be a written response from the official, okay? Shall reply. That's number one. Such reply shall be filed within 30 days of the date the official received the complaint from the city recorder. The commission, however, may shorten or extend the time for the deadline. So, one, do we know when Ms. Hanson received each of these complaints from the city recorder?
We do.
We do.
We do. They were same day. So if we received them in a day, on that day, she received them that same day.
Okay, so if the complaint from Mrs. Jenkins came in on June the 7th, it went straight then to Ms. Hanson on June the 7th?
I think that's correct. Yeah, but within hours, yes.
Okay, and then the last one was received June the 14th, she would have received it then.
Well, let me back up. We received it on June the 7th, but we received it overnight. So technically, no one opened it until June the 8th. So it was, everyone got it around June 8th.
So let me suggest to the commission this. To make it straightforward, and so Ms. Hanson knows what she needs to do, let's extend the time across the board for her to respond to the complaints to a specific day. In other words, the bylaws give her 30 days. So if you apply this, it'd be June the 8th, July the 8th on the first one would be her deadline. July the 14th would be, or July the 15th, one or the other would be the latest deadline. So my thoughts are just ask her to respond in writing to the complaints by a specific day,
I agree. I agree with that.
all of them. And we have the authority under our bylaws to shorten or extend the reply deadline. And my thinking is July the 15th should be appropriate because that's just shortly beyond the 30 days and it encompasses all of them.
The 15th is a Saturday, so you want to say the 14th?
I'd take it over to Monday.
Okay, Monday.
So her time for response to all of the written complaints would be noon on July the 17th. Is that satisfactory, Ms. Wilson?
Yes.
Mr. Sharber?
Correct.
Do we have a motion to that effect?
So moved.
Second.
All in favor?
Aye.
Aye, so it's done. So July the 17th would be her time to respond to all of the complaints in writing. So we need to set a date then to pick our fourth person. Do we have any suggestions on when you would like to do that? Let's work backwards. Ms. Billingsley, when it says within 60 days of receipt of the complaint, the commission shall conduct a formal public hearing.
Your deadline is August 6th.
August 6th.
August 6th, so work from there.
All right, so that's thank you. That's what I'm looking for. So-
I will let you know that Gail Ashworth is available on August 2nd, 3rd, or 4th, if that helps.
And I am not. I'm out of town on that whole week. I'm out of town. The 1st through the 5th, I'm out of town.
She's also available on the 31st and the 28th of July.
28th of July worked for me.
28th?
I'm not available that day.
You're not?
I am on the 31st.
You available the 31st?
And I'm not.
You're not?
That week of the 31st, I am out.
What about the 26th or 27th?
27th, I can certainly do it.
27th, I'm fine.
So we have a planning commission meeting that night, so that might be a problem.
You have a what?
The planning commission meets that night?
Oh, yeah, they always take a long time.
Well, what if
The
we do it at noon?
26th?
Just do it at noon on the 27th.
Can they move that? Okay.
Noon 26?
Gail can't be here on the 27th, but Caitlin can. So
Yes.
I think we can work with that.
Would the 26th be better? We'd still be within our 60 days.
Well, what's the pro and con of doing it at noon on the 27th?
The only con would be that Gail is not available, but Caitlin is available. So you will have counsel. We just want to make sure you have counsel here because I can't advise you on the actual merits
No, I
of this.
understand. So
Yep.
the
So
27th.
there's no con really,
So the 27th at noon, Mr. Sharper, what about you on that day?
I'm fine.
except that we have to be out by 5 because planning commission starts at 5. So you
Well,
have,
we're going to set time limits, so
Yep.
we're going to certainly be done by 5 or earlier. So noon, the Ethics Commission hearing. That'll be July the 27th. All right, very good. So let's back up from that. We know that Ms. Hanson's time for response in writing is July the
17th.
17th. Then we need, between now and the 27th, we need to pick our fourth person. Okay, so when do y'all want to do that?
And the sooner the better, really.
Yeah, oh, I agree.
Is,
How much, Ms. Billingsley, how much public notice do you have to give for one of our commission meetings?
well, we like to work with around at least 3 days.
At least 3 days?
Yeah, but we do have to publish it in the newspaper, so that's kind of our hang up is making sure we can make it into a newspaper with 3 days notice. So our deadline,
So what about July the 6th? Are you all available for July the 6th to pick our fourth person?
I can be here.
I can be.
Okay, noon on the 6th. That's for the purpose of selecting.
yeah, we can make notice for July 6th.
So it'll be noon on the 6th. This will be a Ethics Commission meeting for the purpose of selecting a replacement to hear this matter in lieu of Juanita Patton.
That's a lot of business that you handled just now.
Well, the question I,
You taught us well.
yeah, in deliberating over who that fourth person should be, are we governed by the open meetings statute? In other words, do we have to deliberate in public?
Yes, you have to deliberate in public. The three of you cannot talk together to come up with your nominations. You're just going to have to kind of go out and if you don't have a nomination, you don't have one. If you want to talk with me about trying to, see who you might nominate, if you have any questions about that, I can help you. But the two of you can't meet with a third person who you think might be a good fit. Only one of you can do that.
Only one of us can meet with the person that we're willing to.
Yes.
So each of us can bring a nominee forth for discussion on July the 6th, but no prior communication among ourselves regarding the merits of that nominee.
That's right.
And we should have talked to them.
Yeah, please
see
make
if they're
sure they're
willing.
available on July 27th at noon. If they're not, then move
You
on.
sure don't want 'em.
Because we really are,
Exactly.
yeah, we're tight on time.
Well, they need to be available and they need to be willing to serve. And they need to be willing to listen to or view
The
our
video.
proceedings today to understand what we did and why we did it.
In the interest of doing things correctly, I totally agree with what you said. But should we appoint somebody and something happened catastrophically or something, and they cannot be there? At that point, we don't have to make a replacement because we've already done that, and we still have a majority.
That's right. So it doesn't contemplate for someone missing if they were so sick or something like that
Sure.
happened. It's only if they recuse themselves
Only
for
to
conflict.
recuse themselves.
Right.
Okay.
Very well. Is there any other business before the commission today?
Make a motion, we adjourn.
Second.
All in favor, say aye.
All right.
Aye. We are adjourned. Thank you very much.